Good morning and welcome back to day 2 of the LHPH Virtual Summit. Once again, my name is Trevor Watson, VP of Business Development at LHPH Capital. We hope you all enjoyed yesterday's panels on the lease structure, the key performance indicators, and cash flow from a lease or pay here perspective. Today, we have 2 excellent presentations that are incredibly timely with all the changes taking place in the business environment today. Our first presentation will be on the LHPH legal and regulatory environment in the upcoming Biden era, followed by the economic outlook for 2021 with Dr. Lynn Reeser.
Today we have 2 excellent presentations.
We hope you all will stick around for both these quality sessions today. For the first session, I would like to introduce our 2 presenters, Edward Kay and Sloan Schickler. Ed and Sloan are the managing partners for Schickler & Kay LLP, a New York-based law firm specializing in the financial services industry, commercial and consumer leasing, automotive finance, and commercial finance. They both have extensive knowledge and experience in the leasing industry and the LHPH space itself. Many of you will recognize Ed as the past president and current board member of the National Vehicle Leasing Association, or the NVLA. Welcome to both of you, and thank you for sharing your insight with us today. We are still having some technical difficulties with the chat and questions feature on the platform. So if you do have any questions that you would like to pose to Ed and Sloan, please email them directly to me at twatson@lhph.com. That's TWATSON@lhph.com. And I will present those to Ed and Sloan at the end of the presentation time permitting. So with that, I will hand it over to Ed and Sloan.
Good morning.
Good morning. Thanks, Trevor. I don't know if can you hear that echo, Sloan, or?
I can.
Yeah. Well, I think you may need to mute your audio.
Yeah, I'm having some technical difficulties.
That's better. Sloan, your audio is muted now. You can't hear. You think you muted Sloan?
No, I muted it.
Weird. All right. Well, let's forge ahead. Sloan, why don't you start? Let everybody know who they're dealing with.
Okay. Thanks, Ed. Thanks, Tim. And hi, everyone. I want to thank you for inviting me to join you today and inviting me and Ed to join you today. As Tim said, I'm one of the managing partners of Schickler Kay. I've been in practicing law in the area of leasing and motor vehicle finance for over 25 years. My firm actually pioneered the area of motor vehicle leasing in the country, originally involved with the officer of the controller of the currency when the original Regulation M was developed, and our firm developed a lot of the forms that have been used and most widely knocked off in the leasing industry across the country for the last 30 years or more. I'm very happy at this point to say that Ed and I have teamed up. We've put together a fantastic group of lawyers who have a lot of skills in the area of finance, commercial lending, commercial litigation, and bankruptcy. And we really feel that we have a terrific team that can support us. And we're very excited about moving forward to help people in the LHPH sphere, whether they're dealers or lenders. It will give us great pleasure to be able to work with all of you. Next slide, please.
Why don't I give myself a little bit of an intro?
Yes. Sorry.
So my experience is a little different. I've taken a different track than Sloan. So I know many of you who are participating on this morning's seminar, but I've been in the leasing industry for almost 30 years. And for the past 10, I have been very fortunate to be involved with Terry and George and Tim at LHPH. And together, we developed a really unique program to fund LHPH dealers around the country. So I know many of you who I've had dealings with over the years are on this seminar this morning. I wish I could say it's good to see you again, but from my perspective, I can't see you. But I really appreciate the opportunity that we have this morning to be here. I want to thank not only Trevor and Tim, but my good friends Terry and George, because those guys are really special people in this industry, and I'm really proud to be on their virtual summit. So without any further ado, let's get to the topic at hand. Sloan?
Thanks, Ed. Just very briefly, we want you to understand that anything we discuss today is not by way of giving you legal advice, and that you need to seek your own attorney for any advice with respect to any matters that you decide to undertake based on any of the discussions we've had today. Thanks. Next slide. Okay, so our agenda for today is 3 different topics. The first is LHPH under the recently updated FDCPA, that's the Fair Debt Collection Practices Act. The second topic is the Consumer Financial Protection Bureau under the Biden administration, which is timely, so put your seatbelt on for that. And then the final legal topic is going to be subchapter 5 of chapter 11, bankruptcy, and what every LHPH dealer needs to know about that. And then we'll have a Q&A at the end.
Great.
Next slide.
Wow, a couple of little technical difficulty here. All right, here we go. First, we're going to talk about the Fair Debt Collection Practices Act, and I'll take the reins from here. It's the main federal law that governs debt collection practices, and it prohibits debt collection companies from using abusive, unfair, or deceptive practices to collect debts. In October of this year, the CFPB issued what they called the final rule. And it brings some clarity with respect to communication, or I should say modern communication, to the FDCPA. And when the FDCPA was enacted 40 years ago, email, Gmail, iPhones, text messaging, and social media were not widely used, if even used at all, by the general public. So it took 40 years for them to update the Practices Act, and that's what they did to try to give both, debt collectors and consumers a better understanding of what's permissive and what's not. So for us as practitioners in the automotive field, we want to use this basically as a best practices in our collection procedures. The act is very long. It's 653 pages. It's hard to get through. I can't say I've gotten through all of it myself, but I can tell you that most of it is focused on communication, and that's what we're going to focus on today. First of all, it applies to debt collectors, and it determines obviously who a debt collector is. And most of the FDCPA applies to third-party collectors. Why is this important for LHPH dealers? And there's a couple reasons. First of all, if you outsource your collections, which some LHPH dealers do, you have to be careful that you're outsourcing to a company that's going to be compliant. Because if they're not, and it's your debt that they're collecting, they could get you into trouble. So the proverbial brother-in-law who decides to get into this business because they think the economy is going to tank may not necessarily your best option to collect your debts. Additionally, if you sell bad debt, and some LHPH dealers do sell defaulted paper. Who you sell it to also may keep you on the hook. So you have to be careful who you're selling it to. And lastly, which I think is most important for the dealers that are on this call and dealers in general, is these guidelines are the best practices to follow in the industry. So even if you're collecting on your own account, in order to stay on the straight and narrow, keep yourself out of trouble, if you follow these rules, you're going to have a good faith defense in front of any court, any regulatory authority, that you were following these rules to the T and you complied with them. We'll talk about why there can be some conflicts between your state law and federal law, but as a best practice, if you follow this, chances are you will stay out of trouble. Okay. First method of communication is voicemail. And the question is, what can a voicemail message contain? So the final rule determines what they call a limited content message. And that's the following bullet: the consumer's name, and this is what you can leave on a voicemail: the consumer's name, a request that they reply to the message, the names of natural persons to whom the consumer can reply, a telephone number to reply to, and an opt-out notice. If your message meets those strict requirements, you're safe. Some states, and I want to bring this to your attention, some states require that a debt collector state, this is an attempt to collect a debt. And if you leave that on a voicemail, based on this final rule, you may be in violation of the act. However, your state requires that you leave that message, so you should follow your state law first and this second. So keeping that in mind, you want to review some of the state laws to stay out of trouble as well. But if you follow this guideline, that's the message that you can leave. Next issue is the telephone call frequency limits. So the final rule states that a debt collector is presumed to violate the FDCPA if you place a telephone call to a person more than 7 times in a 7-day period, or within 7 days after engaging a person on the phone. So if you speak to the debtor, you're barred from calling them again for a week. If you don't speak to them, you can call them for up to 7 times in that week. It doesn't mean you can only call them once a day, but it does mean you can't call them 8 times in 1 week. You can call them 7 times on one day and then not again for another week, but you can't call them for more than 7 times in a 7-day period. So if you comply with this, and most companies have some sort of system where they can track this type of activity, again, you stay clear of violating the rule. Time and place restrictions are also discussed in the final rule, and they clarify the times and places that a debt collector can communicate or attempt to communicate with the consumer. The CFPB states that it's okay to collect between 8 a.m. and 9 p.m. local time at the consumer's location. And I give you a caveat or a warning that local time at the consumer's location is an important factor, and you may have to consider it. You know, we live in a mobile society where people move from state to state, and they take their cell phone numbers with them. So I may have a cell phone number from New York and be living in Arizona, and I'm now on Pacific Standard Time. As a debt collector, you can't call that customer at 5 a.m. in Arizona, even though they have a New York area code. So it's your obligation to figure out where they are. Not always easy, and it's not always, doesn't always happen in the LHPH world, but most vehicles in the LHPH and buy here, pay here space have GPS units on the vehicles, so you should be able to figure out where the vehicle is, at least, and then use that as the method of locating the debtor. Email communications. Email is perfectly fine to collect debts. The final rule gives us what we call a safe harbor, a way to stay out of trouble. And you can stay out of trouble if the consumer used the email address to communicate with you, if the consumer consented to the use of the email address to communicate about the debt, and they have not withdrawn that consent. In other words, if they filled out a credit application, listed their email address, and never told you not to use it, it's perfectly fine to collect by email. Or if the creditor obtained the email address from the consumer and the consumer did not ask the creditor to stop using it. Very similar scenario. If the consumer gave you the email address on the credit application and has never asked you to withdraw their consent, it's perfectly legitimate to email. There is a qualifier that I assume many of you know, but if you don't, you should be very careful if you email a consumer at their place of business. So if you know that a consumer has emailed you from their work email address, let's just say, for example, Trevor at LHPH.com emails you and says, I don't have money this week to pay you. You can't reply to Trevor on that work email address. It will get you into trouble if it's looked at, and you can't call Kevin at LHPH Capital either. Trevor. So be careful with work email addresses. Text messages, also entirely legitimate to use as a communication tool to collect debts. And they can be used if the consumer used the phone number to communicate with the debt collector and is not opted out, and we're going to talk about opt-out in a moment. If they've used that text number within the past 60 days, and if the debt collector confirmed that using a complete and accurate database, that the phone number hasn't been reassigned from the consumer to another user. The overriding theme of the entire rule of all these different methods of communication is privacy. So they want to make sure that when you're making a communication or collection communication to a debtor, you're respecting their privacy. And if you violate that privacy, you're going to be held accountable. Social media, also perfectly legitimate as a collection tool, and I might say can be very effective. However, you can't send a message where the public can see that you're trying to collect the debt, or where the person's contacts can see that you're trying to collect the debt. So if you want to use Facebook Messenger, it's private communication between you and the debtor, there's no problem. But you can't post on their timeline that, hey, please give me a call at this number because you're past due on your car payment. That would be a problem. So in general, these new technologies that under the FDCPA, a consumer has the ability to restrict the method of communication that you're reaching out to them. So if a consumer says to the debt collector, I don't want you contacting me by text anymore, you have to honor that. If they state, I don't want to be contacted by phone anymore, the final rule gives them the right to make that request, and it has to be honored. And if you don't honor that and it comes out, whether it's in writing or oral, you can be in violation of the act and subject to civil liability and penalties. So we have a few takeaways from my brief synopsis of the 650-page document. And here's where I boil it down to in simple language is voicemail. If you're going to use voicemail, limit your message to the safe harbor language that we discussed. Hold on, my home phone is ringing. I just gotta get that. Okay, we're all set. So there is voicemail. Keep the safe harbor language. If you don't, it could be a civil liability. There is a prohibition against communicating at any time or place that the debt collector knows or should know is convenient to the consumer. So strict requirements, take heed. Next, you can use email and text messages in debt collection, provided the collectors stay within the safe harbors, and there's reasonable and simple method that consumers can use to opt out. Third, consumers can restrict and designate a particular medium which the debt collector communicates. For example, they can tell you, I only want to be contacted by email, I only want to be contacted by text, and you have to follow that request. And lastly, there's a prohibition from communicating through social media if the attempt to communicate is viewable by the general public with a person's social media contact. The next part of this, which really is the second part of our presentation, is what is the CFPB going to look like with a new sheriff in town? And for that, we turn it over to Sloan.
Thanks, Ed. Yes, we have an impending change coming in Washington, and we're going to see that, as you all know, in the end of January. And the question is really, how is that possibly going to impact the LHPH community? Well, I think you may recall, first of all, we can say that Trump exercised his ability to replace the director of the CFPB during his term. It had been Richard Cordray under the Obama administration, and Trump replaced him with Kathleen Kraninger, who is currently the director. It's safe to say that Biden will exercise the same ability to replace the director of the CFPB. And with that, there's likely going to be other changes that are going to occur. During the Trump administration, we've seen a reduction in investigation and enforcement proceedings on the part of the CFPB. And it's likely that in the next administration, we are going to see something a little different. So you need to be aware and on your toes for compliance issues. Next slide, please. The backdrop of change at the CFPB, who's behind it? What is that about? Elizabeth Warren, you may recall, was the pioneer of the concept of having this Consumer Protection Bureau in the federal government to enforce consumer protection laws. And specifically for you, you have to be concerned about Regulation M as it relates to leasing and Regulation Z as it relates to installment sale, auto sale contracts. Elizabeth Warren pioneered this after the 2008 mortgage debacle because she felt very strongly that consumers needed protection from lenders. And she has been quoted now as saying that it's no coincidence that auto loans are now the most troubled consumer financial product. So it will not be a surprise if Elizabeth Warren has any hand in this next administration that the CFPB is going to be looking at LHPH type of dealers and lenders. We're talking subprime, deep subprime. Next slide, please. The transition team for Biden has two people that are well known that were very involved in criticism of lenders that deal with consumers. One is Leandra English. She was the deputy director under former CFPB director Richard Cordray, and Cordray has been quoted as saying that the Trump administration has left the CFPB as a shell of itself. So we can imagine if she is in line with Cordray as a person that's on the Biden transition team, she's going to be advocating for more serious enforcement of consumer protection laws. Similarly, Bill Bynum, who's the CEO of Hope Credit Union, is on the Biden transition team, and he has been a very vocal critic of payday loans, which, as you all know, are often lumped in with subprime auto lending as a difficult area and a suspicious area, and it's likely that he will also be advocating for heightened scrutiny of consumer protection laws and enforcement. Next slide. A few other areas that may come up are in the area of privacy and data security initiatives. And for the LHPH industry, that really means looking at your systems, your computers, your email, and so on to make sure that you're protecting the consumers' private information that they give to you on their applications and so forth. Another issue that may be looked at again, and it has been off and on over the years, is the elimination of forced arbitration clauses in consumer transactions. And finally, a third area that may come up is disparate impact credit discrimination, which basically relates to seemingly neutral practices of lenders that actually end up having the effect of discriminating against a particular group. Of course, this is all speculation at this point, and there's nothing that has been said that is certain to arise. I think that covers the points that we had for, thank you. The other regulatory agencies to be aware of moving forward into the Biden administration are the FTC, the Department of Justice, and state attorneys general. From your standpoint, thinking about auto dealers, it is most common that investigations start on the state level, which usually means that there's been a complaint made to an attorney general's office that rises to the level that they open an investigation. If the investigation is significant and the lender is in multiple states, an attorney general may reach out to other attorneys general in other states, or may reach out to federal agencies that are required to enforce whatever laws the Attorney General may believe are affected by the auto lender's practice. And that's when you may see the FTC or the US Department of Justice or even the CFPB coming on board for an investigation. This is just a general outline of what could be expected in terms of investigation and enforcement.
So one thing that I think we can agree, and Sloan would agree, that the new, under the Biden administration, compared to what dealers have experienced in the last 4 years, there's going to be a really heightened degree of enforcement, regulation that we haven't experienced in a long time. And, you know, the good news is we still have time to make adjustments in our internal practices and procedures, in our documentation, in our debt collection, in our privacy controls, in protecting data. There's time to do all these things, but they do take time. And you can't start doing it soon enough, because once you are under the spotlight of an investigation or a complaint, and many times you can't undo that. And now you're playing defense instead of offense. So there are firms out there, and we're one of them, that can help you get compliant, that can help you prepare for these types of situations. Number one, before they arise, and number two, after they arise, we may be able to help. So that's just a little bit of a commercial, but the reality is we're going to experience a lot more scrutiny than the industry has in the past 4 years.
Ed, can I just tag on to that before we move on?
Sure.
what I was thinking is if the dealers out there are thinking, oh, it'll take time for this to ramp up till anybody's going to be really looking at us, I want you to think back to what happened after 2008 and with the mortgage debacle, because what's happening now is our economy is in a very difficult situation as a result of the pandemic. And there are a lot of people out there, a lot of consumers out there that may be having difficulty as a result of losing their jobs and so on. And this is going to lead to the advocates like Elizabeth Warren and a change in the CFPB to people looking specifically at how people are treating consumers. So I think the time is here. And if you have been putting off looking at your compliance and procedures, this is really going to be a good time to get a jump on it before the administration really ramps up and is moving forward quickly.
I can just tell you from my own experience, from my own history in the leasing industry, all it takes is one complaint. One complaint to one attorney can spin an entire investigation. And I can tell you, I had a situation with an $8,000 loan that cost over $100,000 to get out of. And it was real. It was one complaint, and it was a nuisance. But the reality is, it can be avoided if your documentation, if your procedures are closely paid attention to and developed and reviewed, and now is the time to do it. The last section of this morning's presentation, I really want to make the dealers aware of. I don't think it's going to be a big issue for LHPH dealers, more so if you do buy here, pay here. But that is subchapter 5 of chapter 11. And that's a new section of the bankruptcy code. It was enacted in February of this year, just prior to the pandemic, and it's titled the Small Business Reorganization Act. Generally, it's an easier, less expensive, and quicker version of chapter 11 for small businesses, and here's the kicker, and individuals, provided their debts are primarily business debts and engaged in commercial or business activities. So before you tune out, you may want to say, well, that doesn't really apply to me. I'm just leasing vehicles to, consumers. Well, if that vehicle is used in the gig economy for Uber and Lyft workers, for DoorDash workers, it's now a business purpose. And that vehicle can be included in a subchapter 5 filing as a business debt. Keeping in mind, and we'll talk about this a little bit further, that the big sale of LHPH has always been that the contract is bankruptcy remote. It makes things much easier to deal with in bankruptcy. Well, this may throw a wrinkle in that argument if your contracts are not set up properly so that they actually are bankruptcy remote. So, I don't know if that was a topic in any of the other sessions during the summit, but certainly it always, it's a key issue with respect to bankruptcy treatment of LHPH leases. The subchapter 5 generally is very similar to chapter 13, which is called like the wage earners bankruptcy or a restructuring for individual debt. It's a 3 to 5 year payout. Debts are not discharged until the plan is completed. It's a very easy process. Debtors can be in and out of bankruptcy in 5 or 6 months. And it gives the debtor time to pause their lenders and other creditors while they figure out how they're going to deal with certain collateral, including their vehicle. So in subchapter 5, a trustee is automatically appointed. Debtor retains, equity and control of their assets. The trustee acts basically as a mediator to get creditors to agree to different terms of the payout. Interestingly, in this, personal guarantees can be wiped out. So if you leased a vehicle to a small corporation guaranteed by the personal guarantor, that guarantee can be wiped out in subchapter 5. So it's kind of throws a monkey wrench in what we all thought was bankruptcy remote lease agreements. Lastly, and probably the most important to LHPH dealers, is cram down is much easier. And a cram down is a motor vehicle loan to an individual in a subchapter 5 case will force the lender to accept payments equal to the value of the vehicle, even though the value is less than the full amount of the loan. You still maintain a lien, but in other words, if you have a lease contract that has $30,000 of remaining payments and the vehicle is worth 15, the court will require that you accept repayment on that $15,000 with the caveat if your lease is not bankruptcy remote. So true leases will probably be able to avoid this, but if it's not a true lease, you could have a problem, and you should be aware that if you see a subchapter 5 filing and you're named in it, don't be surprised. Hire counsel that can help defend, your interest, protect your interest to the best of their ability. So if there are any questions that we haven't answered, or you want some clarifications, or you want to speak to us privately, here's our contact information, phone number, and email. We really appreciate everybody's time this morning, and we appreciate the opportunity to be here. So I want to thank Trevor, and again, I want to thank my good friend Terry and George, two of the nicest, best guys you'll ever meet in any auto finance industry. So that's our presentation for today.
Awesome. Well, thank you so much, Ed and Sloan. We really appreciate it. We certainly appreciate the relationship that you guys have had over the past few years, and looking forward to many more years to come as well. I do actually have a few emails that I received on questions, so let me jump through a couple of these here real quick. Going back to the FDCPA, can you tell us what the penalties related to violating any of those rules might be, or what they might look like?
It's a really good question, and I actually tried to look for some examples of what penalties could look like before this morning, and I didn't find it. I didn't find it in the FDCPA, but it depends on the size, obviously, of the violation. Some of them, have been in the multi-million-dollar range under the existing FDCPA. Smaller entities obviously will have smaller amounts, but if you're made an example of, if you're really not paying attention to what you're supposed to be doing, and an activist, state attorney general gets involved, or the CFPB gets involved, they can put you out of business if they want to. So it's not a clear answer. I'm sorry. If I can find something clear, I'll send it. Email me, and I'll send you some sort of clear answer.
Well, absolutely. Well, I do think it depends on the case and depends on the size of that company for sure, but they certainly do like to make an example, without a doubt. Next question that I had was, what can a dealer do to practically ensure that they are in compliance without breaking the bank?
Sloan, I'll let you answer that one.
What can they do without breaking the bank? What a great question. It really behooves you to go to a lawyer and talk to them about the best practices, to have a lawyer look at your lease form that you're using, or confirm that you've obtained a lease from a reputable party that has produced the lease. And I think in the long run, if you work on your compliance in the first place, you'll prevent something breaking the bank later when you've made a huge mistake. So I would say your better bet is to put a little money into your compliance in the first place, even though it's painful and you really don't feel the initial benefit when you're doing it. In the long run, you'll be better off because you won't have to come to people like Ed and I with a crazy problem that's developed because you use the wrong form, or because your collectors were calling people at the wrong hours, or a myriad of things that can go wrong. You not giving the proper notices for the state that you're working in, the state you're doing multi-states. You have notices that are compliant in one state but not another state. These are not terribly complicated things if you go to an attorney that's familiar with the topic. And I would caution you that you should do this upfront and not wait till later on when you have a problem, because what Ed said is true. You have one mistake on one lease that's filled out wrong, and you could be into $100,000 to lawyers to sort out a class action suit. It's just not worth it.
I would add to that, and this is more of a common sense kind of reply, but compliance now is more important than ever. And you're making an investment in your business when you make an investment in a compliance program, or in redoing your leases, or in auditing your collection practices and procedures. So as much as you make an investment in your capital improvements of your dealership and your lot. And I mean, LHPH dealers that I know are some of the smartest, sharpest operators in the country, in the industry. And many of you have a lot at stake, and you want to protect that interest. And an investment in a good compliance audit is money well spent. And I don't think the good folks at LHPH Capital would disagree with that.
Absolutely. And another question, maybe in the same vein, is from a compliance perspective, what about advertising for LHPH dealers and advertising leases? Is there any exposure in that particular arena?
Sloan, I'll let you answer that one as well. So yeah.
Yeah, absolutely. The Truth in Lending Act covers what kind of advertising that you can have. And if you're doing leasing, that means we're talking about Regulation M. And if it turns out that you're doing installment sales, that's Regulation Z. And you really have to look at that, have someone look at how you're advertising and where you're placing the advertisements and the content to make sure that it's done correctly. I'm sure a lot of the dealers now are doing online advertising. So it's something that you have to be aware of.
And I'd add, at least, we're located in New York. I can tell you the New York State Attorney General is very active in scouring newspaper ads, online ads from dealerships. And in an environment now where the state governments need to raise additional fees, this is easy. This is low-hanging fruit for them. So, and all the states are the same. All the states are very short on money, and there's going to be a lot of regulatory fines trying to be met in this industry and others.
Absolutely. Then I have one more question here. Does anyone foresee any changes on how a repossession on a LHPH lease will look? Do you anticipate it becoming more difficult, or just in terms of whether or not you're the owner as the lessor of that vehicle, any sort of changes coming down the pipe from a compliance perspective?
We should both answer that. I don't see that changing drastically, but I do see, repossession is always a very, sensitive area if you're sued for wrongful repossession. And that's not wrongful repossession won't change. If it's a wrongful repossession, if you breach the peace in repossessing, you're going to have problems. But if you follow your state law with respect to repossession and are compliant with FDCPA, I don't think that it's going to change too drastically. This new bankruptcy situation may change it a little bit. It may cause you to pause the repossession, but I don't see a huge shift in change. I don't know. We never talked about it, Sloan. What do you think?
Well, I think there has been some protection of consumers as a result of the pandemic, but I don't anticipate that would be any long-term effect on repossession. I think what Ed said is true. If you're doing it in a lawful manner, you don't break the peace when you're doing it, you shouldn't have a problem. And I can't imagine that's going to change. As long as you can prove that you're the rightful owner of the vehicle, it shouldn't be a problem.
Excellent, thank you.
No,
If anyone has any,
one other thing I would add, you do have to be careful. There are cases where companies have repossessed vehicles when the balance is, less than $100, and that's going to get you into trouble. So you got to be mindful of what you're going after. If it's a legitimate default, even, post-pandemic, and you follow you tried to do the right way means to collect. You've been unable to. The account is not getting repaid, and there's a significant balance. You're going to be safe as long as you follow the guidance. But if there's any sort of retaliation smell, if there's any sort of unfair practice, that they owe you $100, now you're going to repossess this vehicle, and you're going to earn $5,000 on it. That is not going to pass the smell test. And that's not a legal term, but it will keep you out of trouble.
absolutely, it is definitely good advice. All right, well, we're coming to the end of the session here, and I definitely want to thank you both for a great presentation and lots of really good information. Apologies for the technical difficulties up front, but it looks like we got it all squared away. And for the attendees, next up we have the 2021 Economic Outlook that's coming up with Dr. Lynn Reeser, the former chief economist at Wells Fargo and Bank of America. So we hope you'll stick around for the next presentation. And Ed and Sloan, thank you again. We really appreciate it. And you have a wonderful afternoon.
Thanks a lot, Trevor. Good luck, everybody. Take care.
Thank you.
Thank you.